Hello and welcome to webinar number 4 of our Forensic Mental Health Evaluations webinar series. My name is Talia Warner and I am with the Houston Immigration Legal Services Collaborative. I am a licensed clinical social worker and my work at the Collaborative focuses on managing a system for connecting attorneys with mental health providers and bridging the gaps between legal and mental health services. At the beginning of 2019, a collaboration was created with our partners to bring you a webinar series for attorneys and mental health providers to address best practices in working with traumatized clients and forensic evaluations for immigration cases. The webinar series has covered various topics including trauma-informed lawyering, how and why to use forensic evaluations, interdisciplinary work and collaboration between attorneys and mental health providers, and more. Today's training is the 4th installment of the Forensic Mental Health Evaluations webinar series. This presentation will focus on how to incorporate evaluations and how to prepare the expert for testimony. You will see here a list of the webinars that we have, and they are available and posted through our website as well. The first webinar focused on trauma-informed lawyering, the second one on working with traumatized immigrant children, the third one focused on how to set up the forensic evaluations, and today's webinar is incorporating the evaluation and preparing for the expert for testimony. There is also a 5th webinar that is posted on the website, and this one is specifically for clinicians. It provides a basic foundation for how to conduct forensic mental health evaluations. I'm really excited to be working with today's presenters who have such depth and experience and knowledge in working with the immigrant community. This presentation will be led by Jessica Houghton, Managing Attorney with Tahrir Justice Center, and Chloe Walker, Supervising Attorney with the American Bar Association, Children's Immigrant Law Academy, also known as SELA. So here's our outline for today's presentation. First, we will start off with a brief review from previous webinars, which will provide information on why you would use an expert for your client's immigration case, how to choose the right expert, and how clinical expertise is useful during testimony. Then we will do a deep dive into how to incorporate the evaluation into case and filings, how to prepare the expert for court testimony and testimony, and what happens at the hearing. So I will turn it over to you, Chloe.
Thanks so much, Talia, for inviting me to be a part of this collaboration, and to Jessica. I'm going to start off with the big question, why recap? Why should we use an expert in removal proceedings? If you've made it this far in our webinar series, you might be thinking, wow, it takes a lot of thought, planning, relationship building to incorporate the opinion of an expert witness to an immigration case. So why should you go through all those steps to use an expert? And I think the answer is that, when the cards are stacked against our clients in a system that is not trauma informed, that lacks due process protections, an expert can really be the boost that might help your client across the finish line. And specifically, they can do that by providing additional evidence. We know that the evidentiary burdens are high in many ways in immigration court due to the Real ID Act and the requirement to corroborate everything that we can. So an expert opinion can help meet that evidentiary burden, corroborate your client's story, and support their credibility. And I think this is true not just when you show up in court with your client and your expert on the stand, but throughout the whole process of getting your client ready and prepared to put their case forth in immigration court. And in particular, how clinical expert testimony can help is 3-part. So, when you walk into immigration court, the judges, may have been there for a few months, a few years, or longer than that. But regardless of how long they've been on the bench and regardless of how many times they've heard stories of individuals who have survived trauma in their home countries and on their way to even the United States, having an expert is an opportunity to um, educate the judges, educate the other players in the system, educate your client as they are working with the expert about trauma and how the impact of trauma affects memory, affects cognitive abilities, physical health, all the things that we've talked about on our previous webinars. And then in addition to that, it provides the explanation of some things that might otherwise seem like there's a lack of credibility or seem inconsistent to the judge or to the attorney who's cross-examining. And more than anything, provide that expert opinion, that objective opinion that's based on the particular expertise that you bring that person into court. So, as we've talked about in the other webinars, and just to recap, it's really important to start this whole process by asking yourself the question, why does your case need an expert, and why this particular expert that you're bringing onto the case? So don't just look for an expert because you've watched this presentation or someone told you that it will make the case stronger and that every case with an expert wins. Really stop to think about why the expert is going to be involved and what they're going to speak to. And on top of that, you want to make sure that you find someone who is trauma informed, that is culturally competent to work with clients, with your particular client, whether it has to do with the level of the trauma they've survived, where they've come from, the particular type of trauma that they've endured. You really want to match that up to the expert as best you possibly can. And working with someone who's worked with asylum seekers before, has gone through the HILSC forensic evaluation training, and can really appreciate the aspects of the legal case and the asylum system that may be unique to working with them, whether that's tight deadlines, working with clients who've been traumatized and may, miss appointments or show up in ways that's different than other clients that they may have. And we'll talk more about this when we get to the court piece, but also just remembering the basic requirements of what the expert's going to prove, the relevance of the testimony to the case, the qualifications, and whether or not they're reliable to speak to that topic.
And if I may chime in here, Chloe, so it can be a little bit overwhelming potentially to choose the right expert for your case. There are a lot of different mental health providers out there, and it really is about selecting the clinician that would be the best fit for the case that you're working on or for the client. The only thing that I, recommend in particular, here's a list of providers that you could potentially choose to be your expert for a mental health evaluation. There is no right or wrong choice necessarily in regards of type of licensure. It's really about the particulars of the case. These are all licensed providers that are authorized to assess, diagnose, and provide treatment. There are some differences in the way that they practice, and so that's really what you want to look at in terms of the needs of the case. For example, if your case needs a competency evaluation, for example, you might want to use a psychologist because they have that type of training and psychometric assessments. If you have a client, for example, that you've noted has a lot of physical symptoms in conjunction with some what you feel maybe is a combination of psychological and physical symptoms, perhaps a psychiatrist would be best for that particular case because they do have a medical background. And so those are the types of things that you would look at, in addition to the specializations such as, clinicians that are trained to work with children, if you have a case that you're working on with a child, or clinicians that have special areas of expertise like domestic violence or having experience working with trafficking victims. So those are all very important things to discuss with the evaluator as you're assessing whether they're a good fit for the case.
Thank you so much. So what are the requirements for an expert in immigration court and asylum cases? The federal rules of evidence, they don't strictly apply, but they are a really great guideline for determining whether someone can qualify as an expert. And the three basic requirements for an expert are the relevance of their expert testimony to the case, their qualifications, to be an expert witness and to speak to the opinion that they're offering, and the reliability of the expert opinion. And those come from the federal rules of evidence. And you should really be thinking about that again, in combination with finding the right fit. Once you find that person, these are going to be the questions that drive what you're asking them to speak to and why they are the right person for it. And before we jump into a deeper dive on preparing your experts and presenting expert testimony to present in immigration court, we didn't want to walk away from this webinar without mentioning that expert opinions can also be used in your cases that go before USCIS. Even without a court hearing, even without an interview, expert opinions can really bolster the evidence that you submit, for example, on a U-Visa case or a VAWA case, to provide some, that same bolster to the case, evidence to, to corroborate what happened to your client. And, especially for those forms of relief that require showing the psychological impact of an event on your client, an expert opinion can really help. So on this slide, we have directed you to the adjudicator's field manual, which, are the guidelines for USCIS and how they can and should apply expert opinion as part of the evidence in your case that you submit before USCIS.
Thanks, Chloe. This is Jessica, and I'm going to talk about incorporating the evaluation into your filing and preparing for testimony. So now that you've picked your expert, you've worked with your expert has met with your client and is producing the evaluation, let's talk about what happens next. Well, the first thing that happens when you finally get that expert report is to review it and to review it carefully. So you're going to look at it side by side with the client's declaration. And so the way we're going to look at this process in reviewing the report is to first think about what you as the attorney should do, and then what you and your expert should work on together in the communication. Ideally, you'd be able to get your expert evaluation before you've submitted the client's declaration to the court. Now, this doesn't always happen, and this isn't always possible. But if it is, it's great, because inevitably your expert, your mental health expert, is going to get information during their time with the client that you didn't get. It pretty much happens every single time. Even though you've been working with your client potentially for years, and the mental health expert talks to your client for a couple sessions, for a couple hours, they are trained and have the skill set to be able to get more information from the client sometimes than we are, Talia, do you want to talk about any of that?
Yeah, in terms of, I mean, I've definitely worked on evaluations where, I met with the client, we completed the clinical interview, I completed the report and submitted the draft report to the attorney. And it's not uncommon for the attorney to come back and say, hey, this is actually something that the client hadn't mentioned to me before. And so, there have been times where I've had to, I go back and I talk to the client and we explore, do a deeper dive into this new information, or talk to the attorney whether it's relevant to the immigration case and whether it needs to be included. It's not uncommon. I mean, I think one of the things about when you are doing a clinical interview or just mental health work is that you're able to elicit more information from the client at times, because many times the client has never had access to mental health services, and so this is in many occasions the first time that they engage with a mental health provider, and as such you're able to elicit perhaps information that maybe they weren't as comfortable sharing in other situations, and so it does happen from time to time.
One thing to keep in mind, and we've had it happen with some judges and some ICE attorneys in the past, is that there was an incident of abuse in the client's long history of abuse that came out in the expert report that didn't come out in the declaration. Now, maybe, our declarations don't necessarily cover every incident of abuse. Our clients can't remember every incident of abuse, unfortunately, because oftentimes they've suffered so many. But we've had judges or trial attorneys question, why is this incident of abuse in the expert report and not in the declaration? Now, if you haven't submitted the client's declaration yet, you have the flexibility to decide, hey, is this something that I should add to the declaration? Is this something that I should explore more with my client and include? If you've already submitted the declaration, then you should be aware and ready in case it comes up. Now, it doesn't necessarily come up as an issue, but in case it comes up, then you're ready to address it. Or maybe you choose to ask in direct a question about that incident to your client, because then they've proactively brought it up. So it is in their testimony as well as the expert report. So these are just different things to consider when you're reviewing the expert's report. And if you see something that's not necessarily an inconsistency, it's just there are more incidences being discussed, or the expert, or they highlighted different incidences of abuse to the expert than they did with you in your question, right? I mean, again, the client has unfortunately oftentimes tons of different trauma points that they could share. And maybe it just didn't seem relevant to the way you asked the question, but it did seem relevant to the way your expert asked the question. Now we'll go into working with the expert on edits in a little bit, but first let's talk about goal alignment. So you've reviewed your expert report. You've looked at what's in it. You've highlighted for yourself things that maybe you weren't aware of. And you've also looked for inconsistencies, times where they said they were 12 years old the first time they were kicked out of their house, and the expert report says they were actually 10. You flagged other things that could present problems. What you also need to do when evaluating your expert report is to make sure it's meeting the goals that you've identified as necessary for your case, right? So think about what Chloe was talking about in our previous webinars. You've chosen to get an expert and do all this work for a reason. What are the gaps? What are the evidentiary issues? What are the eligibility requirements you're hoping to have this expert report meet, right? Whether it's your mental health expert or your country conditions expert or your medical expert, whatever type of expertise you're trying to do, what is the evidentiary issue you need it to fulfill? Ask yourself, once you've read the expert report, does it do that? And does it do that sufficiently? If not, this is a time where you need to go back and talk to your expert and ask if they can, if there's more information that came out, if they can increase a section on that. When working with your expert to set up the initial evaluation, hopefully you've already had this conversation. So hopefully your expert already knows the goals that you're trying to meet. But it's a time to go back after reading it and say, oof, I think this section needs a little bit more if you can, because I really need more to quote on, because this is a big issue in the case, and should get the bulk of the expert report, right? So that's something that's important to go back and look at. You're reviewing the facts, keeping in mind the deadlines that you and your expert have already agreed upon moving forward to make those changes.
If I can add here, Jessica, as well, from the mental health provider's perspective, right? I mean, I know that we, as the mental health provider, you can probably go on and on for days about the client's history, and it's important to always keep in mind the goal, right, and the legal needs of the case, because this is where evaluations vary from ongoing clinical work or counseling with the client. You have a very particular goal, and the goal is to provide this evaluation for the immigration case. And so it's important that when you are meeting with the client during the interview, that you have in mind what are the areas that you need to explore with the client, what are the topics that you need to hit in order for you to actually meet the goals that you previously discussed with the attorney. Keeping this in mind as you're conducting the clinical interview will also help to limit any inconsistencies that can come about as you're writing the report as well.
Also keep in mind how you're going to use the report. We're going to talk about that a little bit later, incorporating the expert report into your brief and into things like that. But when you've identified the goals, your goal is to have an expert report that the judge gives a lot of weight to, right? And that maybe even will cite in their decision, giving your client asylum or granting whatever case it is. I've had judges specifically quote, not just once, but many, many times, the expert's report in their decision to grant relief to my client. So keep that in mind, keep those goals in mind, and make sure the language in the report is there that you need to meet those goals. And Talia, your point is a great transition to our next slide about edits and revisions. Again, we've talked about how the expert might get more information. Talia talked about how the expert will hopefully keep in mind the goals that you've agreed on, which goes to the point of, if there's something in the evaluation that maybe is not the most relevant to the case, your case is focused on a trafficking incident that happened, and the report talks a lot about or focuses a lot on childhood trauma. Something to consider is whether or not the expert is comfortable maybe removing or shortening a section of the evaluation. But I will say, be cautious when you're asking an evaluator to remove facts that seem relevant to their diagnosis, right? For us, sometimes as attorneys, we don't understand or see how sometimes the past trauma necessarily is relevant to the diagnosis you're asking the evaluator to find. If the evaluator says, no, they don't feel comfortable removing that because that is essential to their diagnosis, then it's imperative that you respect their expertise as another expert in their field. But I have in the past, for example, if an expert report is very long and I'm concerned about the length of my filing and the fact that what if the judge doesn't even pay attention to the relevant bits, and the entire case is based off of a couple incidents of serious abuse that still makes them eligible for asylum or whatever relief I'm seeking, but the first 4 or 5 pages of the evaluation are about the abuse history that maybe is not so relevant. I have in the past asked experts to please, if they feel comfortable, shortening the section or just hitting the highlights that they think are relevant for the diagnosis, because I really, really want the judge, the TA, if they're going to read it, to read the pages that are really on point to the eligibility requirements of the case. And that's a dialogue that you should have with your expert. You also want to make sure you're flagging any typos or issues. And hopefully you've talked to your expert about what the review process looks like. But keep in mind how you feel when people edit your work, right? It's always nice when somebody's flagging a typo, but it's not great when you are a professional and an expert in your field if people are saying, well, I'd rather, I would use this word instead of that word. If it doesn't actually have an impact on the case or the client, maybe that's not an edit you should be making for your expert. Again, it goes about respect for their time and their expertise. Names, though, dates, locations, that can, though, create an issue for the client's case and unfortunately negatively impact the credibility, even though, spellings change or your client might be illiterate. These are typos that are, on the other hand, really important to potentially flag for the clinician, because that's a simple thing that's an easy fix that doesn't go to whether the client is telling the truth or being credible, that you don't want to pop up and distract and to have a trial attorney try to use to make the client sound not credible. I think anything you want to add, Talia, or maybe we should go to the next slide.
Yeah, I mean, I think the only thing that I could add here or say is it's really important as the mental health provider to keep in mind that we are stepping into the world of the immigration field. And so, while you are definitely an expert in your field, and regardless of what the needs of the immigration case, the diagnosis and the criteria for diagnosing is not going to change. But it is important to keep in mind that stepping into this world, the work that you're doing, and it's not ongoing counseling. It serves a particular purpose. And so it goes back to the goal alignment and that initial conversation that you have with the attorney, to have an understanding that it is completely okay for the attorney to come back and say, hey, I have, some things that I'd like to review with you and potentially, some revisions. I think, we need to be, as the mental health provider, open to having that conversation and always remembering that there is a goal to the evaluation.
Using an expert is a great opportunity for different disciplines to come together to support a client in their seeking justice and safety under our immigration laws. That's something, though, to keep in mind, though, again, the goal alignment in the revision process of making sure that the expert that you're using is sticking to their field. So I've had in my review process experts who, in the desire to be helpful, have maybe, if they're a mental health expert, started including country conditions evidence and research that they've done on the side. And I've had judges be really unhappy with that because they were confused as why your mental health expert, who's not an expert in Honduran family law, is opining about that research, right? So, that's another edit that you might make, but something else that you guys should talk about to be on the same page of the expertise. Also, I've had experts in the desire to be helpful and supportive, as a concluding sentence of the report, say something like, I found the applicant credible and they should receive protection under asylum. Again, judges aren't a big fan of that because the judges are the trier of fact, right? The expert report is just a piece of the evidence being put in, so that's something to talk about in discussing what multidisciplinary collaboration looks like for this case, so that everyone is doing their part to make the case stronger and not necessarily stepping on the judge's toes. A lot of this comes back down to respect. You respect your expert as an expert in the field, whether it's mental health, whether it's medicine, or whether it's on country conditions. With that respect, you have to realize that sometimes you, the attorney, might be the person who's wrong in the situation. This goes back to what we talked about, where the mental health expert might have gotten out more information than you have. And that information might be contradictory, unfortunately, to the information or assumptions that you had maybe made in the case. when that happens, it's on you as the attorney to not assume necessarily that you're the one that's right. Unless this is something where you have the school records and you have other proof and you know for sure the client was X years old living in X location and it's something that you know. But if it's something the client is recalling from memory, like an incident of abuse or who was present and there's no other proof, what I would recommend is to first confirm with the client, right? Ask the client about that incident. Hi, hi client, when we talked before and we went over this experience, we talked about X, Y, and Z. What is this what you remember being true or not? Can you tell me about that time again? I'm sorry, we have to talk about it. I want to make sure we're on the same page. Okay, well, when we talked to the evaluator, you had shared that actually this happened instead. I just want to make sure I'm presenting your story as is correct to the judge. Which one is it? And then work with your expert. Talk to your expert and see if it turns out the way you understood it seems right, or that's what the client thinks the day you're talking to the client. Talk to the expert and see if they want to reach out to the client themselves and talk how they want to rectify the problem or the inconsistency, right? Because maybe the client didn't remember that day, maybe the client didn't understand the question, or maybe the client is sticking with it and that's what they tell the expert one thing and they tell you something else. And it is your job as the attorney to be ready to present the case and deal with any problems that come your way. It happens and that's your job. Anything you want to add to that, Talia?
Yeah, I mean, I think, from an ethical perspective, just in terms of clinical work, right? If this does happen, for example, and the attorney comes to you and says, I spoke with the client, and they clarified to me that this, they're perhaps this is what they meant and perhaps there was some confusion. Would it be okay if you speak with them again? I mean, I think it's definitely important for the clinician to say, yeah, I will absolutely speak with them again. Let's is there something more to explore here? I mean, it's definitely a question. It's not a, it's something that as a clinician you should be inclined to do, is to go back to the client and clarify, and perhaps it's an area that needs to be further explored, and so it is when the attorney approaches you about any of these. I mean, I think it would be important to then go back and meet with the client once more.
But something that's important to consider in the communication through all of this is that it is helpful for the evaluator to understand why you're bringing it up. Why is this inconsistency important to the case? So, or the client. So whenever you're highlighting an issue or highlighting an edit you want to make or asking them to put more work in and talk to your client, make sure it's not a demand, it's an ask, and make sure they understand why, how that fits into the case. This conflict goes to one of the grounds of persecution that I'm trying to prove, and I am worried if it's not addressed or I don't know what the situation or what the client thinks, that they will find her not credible, which means she won't get asylum, right? Because then the evaluator knows why you're asking them to talk to the client again and why this is such a big deal for you. Sometimes, as we attorneys know, what seems like really tiny issues or unrealistic expectations can be absolutely crucial to the case. It seems crazy that we work in a system where traumatized survivors are expected to remember things in chronological order, in perfect sequence, and be able to communicate it in a way where somebody can interpret it into English. But that's the system we're living in. And that's sometimes what we have to remind our experts that we're working within. All right. So in communication, we've had judges and trial attorneys ask the expert what they were given, right? When they wrote the report or when they were asked to do their evaluation. How much information were they given? Were they given the declaration ahead of time? How did they make their conclusions? So that's something to consider when setting up the record. What kind of record are you leaving behind? I don't like to give and don't give my experts the declaration. Sometimes I do for country conditions because it's less relevant because they're not necessarily they're looking at the conditions on the ground, right? So they can see the declaration. It's not as relevant. But for a mental health expert, I've had trial attorneys and judges question why they looked at the declaration before they gathered their own information. That doesn't mean, as we talked about in previous webinars, that I don't provide a summary of the case and I don't highlight other issues that, like, she refers to her grandmother as mom, things that I know will be problems that come up. Obviously, we do that in terms of preparing and communicating, but keep in mind the documents you're sharing and the way that you're sharing them with your evaluator. If you've emailed all your edits back and forth, the trial attorney or judge could ask for those, ask to see the communication. So sometimes these conversations are therefore better had over the phone so that you don't necessarily have a long email train that you don't necessarily want coming up in court. You're not necessarily hiding anything, but you're also, you're not hiding anything. You're just not creating situations where the trial attorney can distract the purpose of the case and distract the purpose of the eval by demanding to see things that really aren't relevant. Even if at the end of the day, the judge says you don't need it, you've still wasted time defending, like not sharing those emails. Another thing to keep in mind is it is completely logical for the judge or the TA to want to know and to have copies of whatever you gave an expert. So for example, we've had medical experts who've done SCAR evaluations and the judge has asked for any previous medical records that were given to that doctor. So keep that in mind. If you're going to give something to the expert, the court might want to know and get a copy of it. All right, so you've got your evaluation. You and your expert are on the same page. You have a final copy of it that's being submitted to court. All edits are done. Huzzah. Congratulations to getting to this point. Now you have to make sure that you're using that report to its fullest advantage in your case. You want to incorporate that expert report into your brief. It shouldn't just be, Exhibit 2, Attachment H. It is, as I've mentioned before, I've had multiple judges quote the expert in their decisions. So make sure you use it. Make sure it's there. So when thinking of the brief, make sure you're citing to it appropriately. And make sure you're setting it up so that it's clear that it's a piece of evidence that truly supports your case. Include all necessary reports. I often ask my country conditions experts, are there any country condition material that you recommend I include as in the country conditions sections? Or I've asked mental health experts, hey, it seems like the impact of trauma is a serious issue in her case. Do you have any reports that you want me to include that you think would be helpful? Include, they could be a great source of further evidence in your case, and make sure that you're including those if possible. Also, you have to make sure that you've got everything set up for your expert to actually testify. It'd be great to have the expert report and the plan to have them testify, but not so great if you fail to actually do a witness list and include them on the witness list, or that you've failed to talk to your expert about testifying in person or over the phone, and they thought they were testifying over the phone, and you never actually did a motion for telephonic testimony. So, again, you're looking at your witness list, and make sure that their CV is actually included in that witness list. It's required under the practice manual. If you couldn't get an expert in time for your filing deadline, but you think it's really necessary, make sure you've done a motion for late filing so that it can get approved and your expert report can be part of the record. Again, the motion for telephonic testimony, you have to make sure to include the number that the court is going to call, and make sure that's the number that the expert wants to do the whole testimony on. It's, if they wanted their work phone and you put their cell phone, that can be a problem. Make sure you've asked for a number that they feel like has no connection issues at that time as well. And, make sure you've thought of anything that the expert wasn't able to get into the report. Make sure you've thought about that in your preparations, not just for your filing, but in your preparations for court, which we're going to get into shortly. All right, so your filing is in. Now it's time to get ready for court itself. So step one, when working with your expert, you have to be ready to tell the court what your expert is an expert in. What is their field? Why are you bringing them to the case? It's very important to decide the proffer in advance. What are you offering up this person as an expert in? Because it's important that your expert is actually involved and agrees with what you're claiming they're an expert in. You guys should be on the same page. Again, keep in mind the goals. If your goal is to have them talk about the fact that they are a survivor, your client is a survivor of trauma, and would face incredible harm if returned because of their mental health, then you better make sure the court is accepting your expert as somebody who's with expertise in the impact of trauma, and maybe even if it's a domestic violence case, or if your case is involving a member of the LGBT community who's persecuted for being a member of that community. You chose your expert based on that. Make sure the court accepts them as an expert in trauma, particularly trauma as it presents in members of the LGBT community. I've had judges and trial attorneys fight back as much as they can to limit the proffer, particularly the ICE attorney. Their job is to limit that as much as possible. So I've had country conditions experts where they've written, and they're an expert in Honduras, in El Salvador, and in Guatemala. They've spent time in each country. They've written books, and the trial attorney is fighting that. How can they be an expert in all three and everything as it relates to the country, right? No, I'm saying they're an expert in this country, and they're expert in domestic violence and the lack of protections that exist for women in El Salvador, for example, right? But that has to be something that your expert's on the same page with, that is supported by their CV, and that meets the goals of your case. Because honestly, your expert's the one on the stand who's got to defend it. So when it comes up, your expert has to feel comfortable with what you're saying they're an expert in, because they're the ones that are responding to the questions from the ICE attorney. You also need to set the stage for your expert. Talk about logistics and what to expect. What does it look like going to court? What does parking look like? What does, the fact that it's supposed to start at 1, what time should they actually arrive? Make sure that you've kind of set the stage about what the process looks like generally. Talia, you've been to court. Anything that would have been helpful to know ahead of time sometimes that maybe wasn't told?
Jessica, I think about the first time that I had to testify. The attorney that I worked with was wonderful in setting the stage for me. I was very honest that I had never had to testify. Though I had a lot of experience doing clinical work, specifically around trauma, I had never had to provide testimony in court. I had no idea exactly what to expect, what it even looked like to be in there, what the wait time would be. be. And so she did a fantastic job in setting the stage for me. She told me, you might have to wait outside for a few hours, and you might not even have to testify that particular day. We might have to come back. And so she was very honest and very clear in setting those expectations for me. It might seem very simple, but she told me take a book, because you might be out there just waiting. And I sure did. I took a book, right? But yeah, simple things that maybe as the attorney, you're used to because this is your day to day. Just remember that for the clinician, potentially they might have never testified. They may have 20 years of clinical experience without ever having to testify. So make sure you give them a good picture of what this could potentially look like, and even include the small details for them so that they feel fully prepared.
I also try to remember to talk about security, what it's like to actually get in, and what the waiting room looks like, because sometimes that can be confusing. I get, here in Houston, we have 1, 2, 3 different, and soon to be 4 different locations where they could be going to court. So make sure you've actually provided the correct address to your expert, and because if they look it up online and put it in Google, they might be going to the wrong location. Another thing that I try to think about in advance is, do I have a second chair, or do I have an intern that's maybe observing, that can text the expert when it looks like we're getting close, right? So, I've had my intern, at certain points when we finish the cross, just give the expert a heads up. Hey, we finished cross. They're going to do redirect, but this is the time that if you're going to, review the report one more time, if you're going to use the restroom, like we're actually getting close despite the hours that have already passed. So things like that. No details too small, and it is helpful because court can be intimidating, and you don't want to waste somebody's time and have them go to the wrong location and be sitting there not knowing what's going on.
And it will happen sometimes. But yeah, absolutely. Those details are never too small, for sure.
You also, past the just generalities of what to expect from, going to that court. You want to also talk about what to expect from this specific judge and this specific ICE attorney. Let the expert know if you're in front of a particularly grumpy judge. It can, things that sometimes seem normal to us as immigration attorneys feels really not normal to somebody coming in. We all had our preconceived notions of what a judge and testimony looks like. But if you're in front of a judge who maybe he's really gruff, but he's a nice guy, let the expert know. This way they're not shocked when the judge, versus like, why are we doing this again? Or why is this person here or is huffing? If you know about your trial attorney, and you know that they particularly hone in on a particular issue, or they tend to, push back, make sure the expert's prepared for that. Or if they're the opposite. There are some ICE attorneys who I've had read magazines during part of the direct testimony. And, if that's going to happen, like, make sure the expert kind of gets an idea of what to expect, because that can be really distracting and off-putting if you don't know that can happen. Trying to think of other particularities of some of our judges. Talia, how did you feel the first time, you were questioned by an ICE attorney?
I'm thinking about the informing piece, and one of the things that was most shocking to me was having, as someone who is bilingual, having to sort of answer questions. First of all, I mean, you're trying to frame your in your mind what, you hear the question, you want to make sure you're answering the right question and trying to frame everything, and all of that while you're hearing the interpreter in the background. I mean, there's simultaneous interpretation. That was something that was very shocking to me, right? Because as someone that speaks two languages, and I was asked to this client was receiving simultaneous interpretation from English to Spanish. And so in my mind, it actually made it a little bit more difficult when I was responding to the questions, because it was, as I was speaking, I was listening to interpretation, and of course, being bilingual, my brain was also processing the other language, even though I know it. I mean, it was like with the way that language works. If you speak the language as well, your brain is processing that. And so trying to stick to what the attorney asked me, stick to my my response, could have a good cogent response, and then on top of that, sort of stop that immediate like interpretation that my brain was automatically wanting to do. That was actually one of the most interesting things the first time I testified. Believe it or not, the most difficult piece for me in particular was that is sticking to the point that I was trying to make sure that I responded to the questions and stick to just what I was trying to say, with just ignoring the interpretation that was in the background. And it's something that I didn't think about at all. I mean, it was not at the forefront, but yeah, it was one of the challenges.
So I think we can go to the next slide. We've talked about the generalities, we've talked about the particularities. It's also a good time to review, to kind of discuss the questions, to also see if your expert has testified numerous times, they might have a particular order of how they like their qualifying questions to be asked. That's great. Review that with them and talk about the flow of testimony. We all have different ways that we organize information in our brains. So you want to make sure you and your expert are on the same page in terms of the flow of testimony. All right, first we're going to talk about the qualifying questions, and then we're going to offer you up as an expert in this proffer that we've both agreed on. And then I want to start with talking about the impact of trauma. And then, my thought is we'll go into this topic. And then, it might and might not come up, but I'm concerned that this client is going to disassociate on the stand. Or in my years working with a client, when she gets stressed, she tends to forget things and go slack-faced and just stare blindly. Like, if this happens, I'm going to ask you these questions to put it into context to help rehabilitate her credibility. Right? Make sure you guys are on the same page of what the flow, the order, and what to expect.
I have a question for Jessica and Talia. How do y'all, I guess, decide, and maybe more for Jessica too, but just what questions to ask, like that are parallel or similar to information that's in the report versus, topics that are outside the report or that may come up in testimony otherwise?
That's a great question. Your testimony with your expert doesn't necessarily just regurgitate everything in the report, right? It can highlight issues that are relevant, but the judge is not going to be happy if you're just having the expert essentially read their report back into the record. And so some things that I look in is whether the TA, I thought the TA would, and this is a weakness of the case, and they particularly hounded on why this DV survivor didn't leave the abusive relationship. That's something that I have flagged ahead of time, and I have talked to my expert ahead of time. It might be in the report a little bit in terms of, she didn't decide to move, but the report might not go in depth into combining the impact of trauma, her mental health at the time, and the fact that she was a trauma survivor in that particular moment. And so your testimony is a great time to give your expert the space to put all those different pieces of their report together in a presentable way. So I'm looking at what I thought might be the weaknesses of the case, and then also what the judge or the trial attorney was asking in cross, to make sure I've addressed all those issues, if possible, from that expert. If it's a country conditions expert, you're talking about, you're having them really highlight the laws and protections that might not have existed for somebody if they wanted to leave an abusive relationship. If it's a mental health expert, and they've specialized in DV, I might be asking them specifically of, kind of like the sitting duck syndrome and what happens, like what are the dynamics of domestic violence, right? So that they can help put those issues in context. So, some of it you're pulling on the fly, but oftentimes you know your case, you know your weaknesses. You've identified them ahead of time to the best of your ability, and then you're allowing yourself the flexibility to pivot, and bring up use your expert to address those issues. Now, if there's a weakness in your case, and for some reason the trial attorney never really pounded it, like didn't seem to think it was an issue that the client spent 3 years away from their abuser before they reconnected, then you're making a judgment call. Do I really want to bring that issue up to the expert in testimony? And maybe the answer is no. But this is where you, as the attorney, are making kind of those judgment calls. And you've talked to your expert ahead of time of, I may talk about this, I may not. If I don't ask that question that we've practiced 5 times, it doesn't mean you did anything wrong. It just means, it wasn't relevant. And remind your expert that they're not going to be there to hear direct. So you might be changing questions on the fly based on what happened in the part of the hearing that they weren't able to hear.
Jessica, I've also I think it's definitely important, this piece, and to discuss the flow. But I've also had the experience where the judge may cut in, and I had a situation where the judge told the attorney, well, I can read that in her report, and then directly asked me a question around trauma and how it impacts the brain, because potentially there was an inconsistency with having reported a crime before and not remembering if it was for a first crime or a second crime. And so he really wanted to know whether, how trauma impacts memory, and if it had a direct impact on the client's ability to report something to the police in home country. And so just the fact that we had reviewed the flow of testimony and all of that was really helpful, even though the judge sort of put a stop to that and just started addressing me and cut off the attorney. I still had an idea, because of the flow, because of the topics and the goal alignment that we had discussed initially. And so sometimes that can happen too. And it's important as the clinician, as the evaluator, to know that there is potential for that, but to not let that sort of shock you, because it's still part of the flow of testimony. It's still addressing the issues that you would have otherwise reviewed with the attorney.
That's a great point. I'm so glad you brought that up, Talia. Yeah, the judge could completely derail it, right? You have this perfect flow that you and your expert have practiced, and you don't get a chance to really do any of it because the judge takes over questioning. And Talia highlights the importance of all that work that you've put into being on the same page, because it pays off in spades once, if the judge totally derails your process. And Chloe will talk about it a little bit more, but you both should be ready to what happens when the judge really is like, why do I have to listen to an expert? That you've submitted the report, that's good enough, and what your options are, right? Because you, as the attorney, you're always thinking what's next and what's ahead, right? We're there presenting to the IJ, but if they deny, we got to be also having thinking about the record and appeals on our mind, right? So it's our job to kind of think about what happens next, or what's the worst case scenario at every step of this process.
Yeah, and I think the only thing I would add there, because I know this from many, many clinicians that have been doing clinical work for a long time. I think one of the scariest parts about taking on this type of work is the testimony, right? Um, this is a good opportunity to show what you know. If the situation happens where the judge starts asking you questions and it maybe takes a different turn that you had practiced with the attorney, it's a great opportunity to share what you know about share your expertise. We had talked, Chloe had gone over what your area is and what you provide in this work, and it's you can talk about provide the education, the psychoeducation about the impact of trauma in memory consolidation, memory retrieval. All of that is important, and it's your opportunity to share what's beyond your report, and provide that in-depth explanation to support and advocate for the client.
100%, Talia. It helps to highlight sometimes the unfairness of the whole system and the process.
Mm-hmm.
And that's always a win for your client and for the clients that come afterwards. So I wouldn't stop at the review, even though after the review, you guys are hopefully on the same page. But really do set up some practice sessions, unless your expert's like, look, I've done this 500 times. I really don't need to practice. Even then, sometimes I ask, look, can we just do one short one for me? Like I just want to make sure that you and I are on the same page. Even in those situations, I still try to get one practice in, just to work on certain transitions and just to talk about certain issues. So don't stop at reviewing, actually do a couple practice. Again, practice the potential questions of, well, I wasn't expecting all that to happen during direct. So I'm going to ask about the impact of trauma. Is that too broad of a question for you? Or does that make sense? Like, do you know where I'm going if I'm asking that question? Because you don't want to be asking questions and the expert's like, that triggers nothing for me. I have no idea what you're actually talking about. You also want your expert to feel comfortable. And it's also worth having them know, look, if for some reason you're on the stand and your brain just fizzles out, it happens. I can actually show you a copy of the report you submitted and say, is this the report? Is this your signature? And let you see it. It's also a good opportunity to remind your expert to maybe bring a copy of the report with them to court so they can sit there and read it if they're getting nervous, just to help ground them. If they're like all of a sudden while sitting and waiting for their time to testify, are feeling nervous, it's one more thing for them to review so they feel ready. I would also practice cross questions. Your expert should not be expected to know the difference between a direct question and a cross question, or what's an open question and a yes and no question. It can be very overwhelming for somebody when all of a sudden you have a trial attorney saying yes or no. The trauma happened years before and it really wasn't relevant at the time the client fled. I mean, the problem is the answer is yes, the trauma happened years before, but no, it is still relevant, right? So how do you prepare somebody to answer these questions that are intentionally compound, that are intentionally confusing, when you've got a trial attorney saying, yes or no, I asked you yes or no, why can't you answer a question, right? Practice some aggressive cross questions so that your expert feels ready to deal with a potentially more aggressive trial attorney's style.
And if you're a clinician and you are new to providing testimony, I think this is one of the strongest tools that you can use is having the practice sessions with the attorney. For me, the first time I did this, I was really nervous, as are most clinicians if they've never provided testimony. And this was probably the scariest part was the cross questions. And I have to say that having had examples, having had, I sat down with the attorney, we discussed what were potential cross questions. That made me feel more confident when I was actually providing testimony, because I felt that at least I had a knowledge of how to respond to questions that could potentially be a little bit more aggressive. And having had that practice it was just immensely helpful. And so I really do recommend it if you are new to this work. Like I said, you could be a clinician with many years of experience, but this is definitely a different beast. And so that those practice sessions are key. And even for a clinician that potentially has been doing this work and has provided testimony in the past, if you have a case that is particularly difficult, perhaps there is a lot of complex trauma, a lot of events that happened, I still recommend doing practice sessions, because that is going to help you stay on point. And again, it helps with the goal alignment as well.
The other good thing about practice sessions is that you'll get to know your expert's style of speaking. Hopefully that's something that you've kind of become familiar with when reading the report. What I've had to do with sometimes when an expert writes a report is to ask them, wow, that's a lot of technical language you put in this conclusion. Do you mind adding a sentence in that following the technical language, summing it up in layman's terms, so that like the judge can cite, so I can cite to the layman's language, or the judge can quote the layman's language. I've had to do that in reports, but I've also had to do that in practice sessions. Like I'll ask a question and I get a very technical response. And we've practiced, when I say, well, what does that actually mean? The expert is ready to say, oh, let me break it down, right? Because you want to make sure that the judge, who's the trier of fact, is like truly hearing and understanding what the point is that the expert is trying to make. So that's another benefit of practicing, is that you get to know if your expert tends to provide more technical explanations, and whether you need to be ready to break that down for the judge and break that down for the record a little bit more. But again, that's something that I should have mentioned, but you keep in mind also for your written report, because when you're citing in your brief, you really want to be able to cite something that you're, because you're not the expert, right? You can't explain what the expert meant. You want to be able to cite the sentence of the expert explaining something that's understandable, and you want it understandable in live testimony. All right, I'm going to pass it over to you, Chloe. We've prepared our witnesses, our experts are ready. Let's talk about what happens at the hearing.
Awesome. We're in the home stretch. And hopefully what you've gathered from all of this is that so much of what happens in court is about preparation and everything that you do in advance. But we want to close out and make sure we cover what will actually happen in court when it comes to your expert witness and the evidence, so that you make sure you cross all your T's, dot all your I's. Like Jessica mentioned, so much of this is about creating a record that the judge needs to either put in their opinion, or if you need to appeal, making sure that that what you need is on the record. So first, let's talk about evidentiary issues. So one of the first sort of procedural aspects of your case that's going to happen in immigration court is the judge is going to review everything that's already in the record or that's been filed. And that will include, as Jessica mentioned, filing your expert report that you're submitting into evidence, and your witness list and everything in advance. So the judge is going to go through that, but it's critically important that even though you've filed the report, that you make sure it's admitted into evidence at the beginning, and that any objections that the government attorney may raise are addressed, and that there's a ruling that your expert report is admitted in to evidence clearly. Now, this may be a point when you may bring up some stipulations that you may have entered into or discussed with opposing counsel in advance. Perhaps the judge is prompting you on the fly to consider and speak to stipulations about your expert. And here's where you need to be prepared so that you can hold your ground and not be pushed into stipulating to something that may ultimately harm your client down the line. So when we're talking about stipulations, I think it's great if you can get the government attorney to stipulate to the admission of the report and to stipulate to the qualifications of your expert, to stipulate to the proffer that Jessica mentioned that you're offering the expert for, the expert opinion that they're going to give. If you can get them to agree to all those stipulations, great. It's going to save you some time from having to, lay out the predicate questions with your expert. And go through all that. You can really focus on the meat of what's in the report. But what might happen is that either opposing counsel or the judge might at this point say, well, why do we even need the expert to testify? Let's just submit the report. The judge will read it. It's been cited to in the brief, let's save everybody some time. We've got a lot of cases on the docket. And here's where you need to be really clear in advance about why you want your expert to testify and why you don't want the judge to just rely on the report. And I think there's, several reasons why that Jessica and Talia have mentioned as they were talking about preparations, but get really clear in your head about or on your proof chart, your evidentiary chart, what are the things that are already in the report that are the pieces of evidence that prove the elements of your case, but then what are the things that you can really only get from your expert with testimony, or that you really want the judge to hear? Because if your response is, I just really want to hear the words come out of my expert's mouth, the judge might not be compelled by that. You need to be ready to prove why you need their actual testimony to present additional evidence, to put the report into context, to respond to any credibility or rebutting evidence that has come up or that may come up on direct. So I think it's really important that at this point that you don't, if you can, waive or stipulate to your expert actually testifying in the case, even though you might be stipulating to her expertise or to your proffer or other things.
I think that's
go ahead, Jessica.
Really important point that you bring up, and I think part of it is if the judge is pushing, if you are fighting with the judge and the judge is just not being swayed, nope, we're stipulating to the report, it's in the record, good enough. Make sure your objection to that is on the record. What can happen sometimes is all those conversations happen off record, and that does you no good on appeal. So if you're appealing because of, one of the reasons is that the judge did not allow you to put the evidence on the record, you have to get that objection, that formal objection on the record, even if it means telling the judge, all right, I understand that you don't want to hear testimony. Can we please go on the record so that my objection can be noted? And it's hard sometimes, right? It's hard to feel like, the judge is getting angry and you're trying to find the balance of not, angering the judge so much that it does a disservice to your client, but you have to be thinking ahead.
Thank you so much for highlighting that, Jessica. and just being clear. I think like at the beginning, like there's a lot of adrenaline, right? When all this like procedural stuff is happening and you're like ready for your case. And going back to that like second chair or person that's kind of, helping be a neutral observer, like sometimes it's even hard to, if the judge is going to say on the record or off of the record, but like make sure you are like cognizant in that moment that you know whether you're on the record or off the record or and clarify that. I think that's a great point. Anything else you want to add on the evidentiary issues or kind of setting the stage at the beginning of the hearing?
I think you covered it, Chloe.
Awesome.
Those were all great points.
And again, keep in mind, the expert's not going to be in the room when all this is happening. So part of that context for, whether you have they're not going to be in the room when you're having this conversation. So at some point, you're going to have to update them on whether or not they're going to testify or whether or not, if you have a moment to let them know whether or not they're going to have to speak to their qualifications and all that good stuff. Okay, so if you get to the point where you do have to qualify your expert and go through that process, then, this is the point when your expert is in the room and on the stand. You've already gone through probably your direct and cross with your client and maybe potentially other witnesses. But before you can even begin to ask questions and get opinion from your expert, you need to qualify them if it hasn't been stipulated to. So it seems, you've practiced these questions with your expert in advance, and it may seem again sort of like trivial, like where did you go to college, what is your degree, and like talk to me about that specialty that's on your resume. It may seem like it's all there, but again, if for some reason the judge rules that your expert's not qualified, you want to make sure that you have as much supplementary information on the record that you can, that maybe doesn't show up on that one line on the resume. Okay, well, what does that certificate really mean? What, does your licensure as an LCSW, take? How many hours, did you have to put in, et cetera, whatever it is that focusing on the expertise, again, that your expert is relying on to put forth their expert opinion. So you want to make sure that you do that, qualify your expert, and also again, you want to put forth that proffer, like don't forget to include it after all that work that you've done to prepare for it and work with your expert on it. And then, probably this is where you're really going to be prepared to respond and redirect on whatever cross-examination questions that the government attorney is going to ask to try and, undermine qualifications, undermine the relevance of the expert opinion to the case, or undermine the reliability. So this might be, where those questions come up that you've hopefully practiced or considered with your expert, or talked about. The number of times that they've testified, which you would think would maybe be, prove that they're qualified to do this. But, sometimes I think an opposing counsel might be trying to show bias or ask questions about whether or not they're getting paid. The lack of firsthand knowledge about all this. This is all just hearsay of what, the client told them. This is where those questions about, well, what documents did you rely on other than the client, that kind of thing. So this is, your chance to lean into that preparation that you did with expert and potentially come back on redirect and address any of the questions that come up about qualifications, about the relevance of the testimony, or the reliability of the testimony. Yeah, Talia, have you ever had your qualifications questions, and how did that feel?
I have not, but I have had colleagues had this happen to them. And what I can say about this is that We talked about review and practice with the attorney. I think one of the things that has helped me to feel, because the imposter syndrome is normal, it happens to all professionals, clinicians who are amazing clinicians and possibly have never testified. So maybe they start to question, wait a minute, am I really an expert? And the answer is yes, you are. But really having reviewed and practice with the attorney, this how you're going to get qualified, like, reminds you of why you do have this expertise and why you do qualify as an expert. Looking back at the first time that I did court prep, one of the questions, like, the attorney gave me a list of questions that she could potentially ask me for the qualifying piece. And I started to think, you know what? Yes, I've actually conducted well over 500 psychosocial assessments before. Yes, actually, yes. When she asked me how many times or how many people, how many groups I've run, I started to realize, yeah, absolutely. I guess I never thought about it, right? Because you're in and day out just doing this work, you don't think to qualify yourself as an expert, right? But when it comes down to it, when you're practicing and reviewing, you start to realize, you know what, that imposter syndrome does not need to be there. Like, I am an expert in this field, and I know what I'm doing. So, you know, for me, it hasn't happened where my qualifications have been questioned, but I can tell you that from having prepared and practiced with attorneys before and how they would qualify me, it has prepared me for if and when it does happen.
Yeah, I think that's a um, great point. Um, and yeah, and again, so you'll go through this process again. You want to get that official ruling from the judge. Okay, the expert is qualified, the proffer's been offered and accepted, so that you can move forward and then begin with the questions that are relevant to the case. And then to close out, Jessica spoke to this in preparation, and it's going to come up again here, but really thinking through, just like you would with any other witness, but the expert witness is uniquely situated because they're, depending on the order you pick, but I think oftentimes they're going to come later in the case or after your other witnesses. You really, need to absorb and have been thinking about during your direct examination or during the testimony of your client or testimony of other witnesses. What are the things that are coming up that I really want my expert to address or speak to, maybe in addition to my checklist of things that I know that I want to put on the record because they're evidence that speak to eligibility. So, part of that is going to be just your trial skills preparation in terms of however you want to organize or gather that information, but make sure that you're not only asking the questions that you've, thought of and prepared in advance that speak to, you know, particular incidents or opinions that you want, but you're also thinking about what came up on your client's testimony. And that's a really roundabout way to talk about addressing credibility of clients. But one of those things that may come up is the credibility of your client. And, like Jessica mentioned, there are some things that, after spending so much time with your client, after they spend time with the expert, after you read the report, you just know that they're probably going to come up in court. And you're going to be ready to address them. And then there just might be other things that come up that you weren't prepared for. Testifying is stressful for anyone. Undergoing cross-examination is stressful, and there just might be things that happen that you want to make sure you address and ask those questions. Again, you've probably prepared some of these questions with your expert in advance, knowing that potentially this was going to be an issue, but asking them to speak to how trauma impacts memory, how trauma may impact how your client is presenting themselves in court, and sharing the information with the judge in the event that you think that any of that is going to go towards credibility. Because I think credibility is, often one of those, it's like when we're talking about appeal, it's one of those things that's hard to have on the record, other than just, conflicting information. It's hard to overturn the judge's opinion on credibility when you don't have that concrete evidence. And the expert is going to be one of the strongest pieces of evidence that you have to support credibility at the immigration court level, or potentially on appeal if you need it.
I think that's a great point also, and how you use your experts, especially if you have more than one expert. If you have a country conditions expert and a mental health expert, both of them can actually be useful to deal with a credibility issue that came up for your client. And you have to be able to think on the fly of how to use all these different tools in your toolbox as your client's advocate, right? So if the client got hung up on cross about their relocation and they couldn't remember if they went to this town first or this town, or if they talked to police here or there, and they're getting all flustered, and the trial attorney is really hounding, well, which one is it? How can we believe anything you're saying if you can't keep this straight? You have your country conditions expert who can kind of put it in context. Well, it doesn't really matter, which one she went to first. There's no infrastructure in either of those places that offer protection for them. There is not police protection for survivors of domestic violence or for trafficking or whatever is your case in either of those locations. They're helping, that their country conditions expert might be helping to make the point kind of irrelevant, like it doesn't change the reality on the ground. And your mental health expert can be the person who puts memory in context. Well, because of trauma, it makes sense that, especially given the client is illiterate, that she doesn't use the same tracking of time in this time of true upheaval and chaos, and that she can't recall with perfect detail now in a time of stress, right? So you've managed to use both your experts from different perspectives to be able to address one credibility issue that came up on cross. And that's the great thing about experts, is that they can really help address from different perspectives problems that come up along the way in live testimony, when they're really all you got, right? You can't submit another document, you can't do more research, you can't put another report into the record, but they're there to help you at the last minute make sure your record is as strong as it can be.
I love that. It's like magic, putting all the puzzle pieces together. So with that, I think, hopefully you get a positive result for your client. If you don't, you appeal, and you keep appealing until, you talk to your client about it, get their consent, and every case is different. But hopefully all these steps have given you a place to start on working with experts and building that into your case.
Thank you, Chloe. So that concludes the information that we had for you today. I did want to share that if you're looking for a forensic evaluator, HILSC, our forensic evaluations stipend program will be closing in June of this year, but I'm happy to announce that we will be the internal database that we have of evaluators will be made public. And so we are happy to announce that we're going to have a forensic evaluator directory. And there's more information to come in June, but just look out for that.
Can I just say, HILSC has been such a tremendous asset, I think, to practitioners in the field, in providing not only, these trainings for attorneys and for clinicians, but just helping close a much necessary gap in building the capacity of everybody who's out there. And I think this directory is just going to be icing on the cake of those resources. So I just want to say a huge thank to HILSC.
Thank you, Chloe. I've been so proud of this program. One of the biggest things that we've done is build this network of clinicians who do this work and do an amazing job. And I'm so happy to to leave this program with this wonderful resource for our legal partners. And of course, this webinar series as well is a legacy of this program, in partnership with you guys. And so it will remain available through our website, and you will be able to access it as well as that directory. So that concludes webinar number 4 of the Forensic Evaluations webinar series. Thank you so much, Jessica and Chloe, for participating and for sharing your vast knowledge and expertise in this work, and for giving us your great insight. I also want to thank the colleagues who both collaborated and presented throughout this series, including Dr. Jody Berger Cardoso, Dr. Luis Zayas, Rosalie Hyde, Marissa Peterson. It's been wonderful working with everybody on this project. We hope that you have found this webinar series useful for your practice. And thank you for taking the time to review the series. Your contributions to this work have a direct impact on what otherwise is a very significant barrier to individuals and families to this, thank you for contributing your unique talents to this very important cause. And it's an honor and privilege to work with everybody that's doing this work. And thank you again.